Hello, I am Johnette, CEO of J. Michelle Jewelry. As an independent consultant of Paparazzi Accessories, I stand by their mission to bring strength, independence, and empowerment to individuals and their families by building confidence and financial freedom through affordable fashion. While $5 jewelry may not change the world, Paparazzi believes those who wear it will. I believe in you. Plus, stylish paparazzi jewelry equals a beautiful, stylish, empowered life. So go out there and live that beautiful, stylish, empowered life you were meant to live. I created this channel to help new independent consultants of paparazzi be successful. Every consultant is a business owner, and as a business owner, you must develop consistent, effective, and efficient business acumen for a positive outcome. I believe in systems and processes. I believe in dreams. I believe in goal setting. I believe in faith. I believe in you. So let's do this thing. My paparazzi consultant ID is 379001. Just go on to paparazziaccessories.com/379001 and click join my team. And as soon as I get notification, I'll call you up. Yes, I will. Alrighty, so if you've been following me, we are doing or reviewing, reading, going over the paparazzi policies and procedures. If you're like me, I listen to podcasts, I listen to books, I listen to YouTube channels as I am maneuvering throughout my day, while I'm driving, while I'm cooking, while I'm cleaning, not so much while I'm doing other work, but I would say a lot of my day I am listening to things that are going to help improve my life in one way or another. So I thought it might be helpful to read through each of the sections. So there's a video for each section of the policies and procedures so that you can listen and read. All of us learn differently, so you choose the best method that is best for you. You can rewind and re-listen. You can listen first, then go read. Do what's best for you, but it is here for you, to help you. So section 10 is dispute resolution and disciplinary proceedings. Alrighty. 10.1, disciplinary sanctions. A consultant's violation of the agreement, any of its components, these policies and procedures, or the violation of any common law duty, including but not limited to any applicable duty of loyalty, any illegal, fraudulent, deceptive, or unethical business conduct, or any act or omission by a consultant that, in the sole discretion of the company, may damage its reputation or goodwill, may result at paparazzi's discretion in one or more of the following measures being imposed on the consultant. You. 1. Issuance of a written warning. 2. Requirement that the consultant take immediate corrective measures. 3. Imposition of a fine, which may be withheld from bonus and commission checks. 4. Loss of rights to one or more bonus and commission checks. 5. Paparazzi may withhold from a consultant all or part of the consultant's bonuses and commissions during any period of investigation involving an alleged violation of the agreement. If the consultant's business is terminated for disciplinary reasons, they will lose all rights and will not be entitled to recover any held commissions. 6, suspension of the individual's agreement for one or more pay periods. So remember, it's saying that if there is some type of disciplinary action, Paparazzi at its discretion will uphold one or more of these measures that I'm reading off to you. All right? So 7, involuntary termination of the offender's agreement. 8, any other measure expressly allowed within any provision of the agreement. Or 9, in situations deemed appropriate by Paparazzi, the company may institute legal proceedings for monetary or equitable relief. In the event that a written warning is issued with specific request of compliance or action, such agreed to terms between Paparazzi and the disciplined consultants are considered an appendant agreement to the consultant agreement, and a violation of such terms may warrant, at Paparazzi's full discretion, any or all of the actions detailed above. Let's just not get ourselves in trouble, right? Let's just not do things we're not supposed to do. That's why I am reading this to you. That's why I'm talking through it with you. Excuse me. So that to your very best ability, you can avoid any disciplinary action taken toward you, because you are following the consultant agreement. You are following the policies and procedures, right? All disciplinary actions are considered confidential and should not be discussed with uninvolved parties. Resolutions and outcomes are not required to be made public knowledge. All right, so that's a lot there. If you find yourself, when you become an independent consultant, or those who are new independent consultants, or even have been doing this for a while, you may want to read 10.1, Disciplinary Sanctions, if you think you may have done something in violation of our agreement. 10.2, Grievances and Complaints. When a consultant has a grievance or complaint with another consultant regarding any practice or conduct in relationship to their respective Paparazzi business, the complaining consultant should first report the problem to his or her sponsor, who should review the matter and try to resolve it with the other party's upline sponsor. So if I have an issue with another consultant, the very first thing Paparazzi is saying I should do is go to my sponsor, the person I signed up under, so that my sponsor can then go to the other consultant's sponsor to try to resolve the issue. It says, if the matter can't be resolved, it must be reported in writing to Paparazzi support. Paparazzi support will review the facts and resolve the issue at the sole discretion of the compliance department. All right? That's pretty simple. 10.3, Arbitration and Jurisdiction. Any dispute or claim arising from or relating to the agreement, including these policies and procedures, or any other claim or grievance against Paparazzi in any form whatsoever, including but not limited to economic losses, personal injury, property damage, will be subject to mediation at Paparazzi's corporate address using a neutral mediator at Paparazzi's choosing. So if you have a dispute or a claim that you want to take up with Paparazzi, it is saying that the mediation will occur at Paparazzi's corporate address using a neutral mediator of Paparazzi's choosing. In the event that Paparazzi and the independent consultant are unable to resolve their dispute through mediation, Paparazzi and the independent consultant will be subject to final and binding arbitration to be held in Salt Lake City, Utah. So be ready to travel if you have any disputes or claims against Paparazzi. The arbitration will take place before a panel of 3 arbitrators to be selected as follows. The independent consultant shall select 1 arbitrator. Paparazzi shall select 1 arbitrator. And then the selected arbitrators will select a 3rd arbitrator. The 3rd arbitrator shall be an attorney. The party initiating the arbitration will identify its arbitrator in its written demand for arbitration to the other party. Listen, because this is about 6 paragraphs. So listen to this carefully. The other party shall identify its arbitrator within 5 days of receipt of the notification of intent to arbitrate. The 3rd arbitrator must be selected within 5 days of the appointment of the 2nd arbitrator. Paparazzi shall pay the fees of its selected arbitrator. The independent consultant shall pay the fees of his or her selected arbitrator. And Paparazzi and the independent consultant shall equally pay the fees of the 3rd arbitrator. The dispute will be subject to rules of arbitration agreed upon by the majority vote of the arbitrators. I'm going to get tongue twisted in a moment. And they will be communicated to the party within 10 days after the arbitration panel has been completed. The prevailing party in any arbitration proceeding shall be entitled to receive from the losing party all costs and expenses of arbitration, including legal and filing fees. So the winning party in the arbitration proceeding can receive, or they are entitled to receive from the losing party all costs and expenses related to the arbitration. Then let's see, the decision of the arbitrators shall be final and binding on the parties and may, if necessary, be reduced to a judgment of any court of competent jurisdiction. The decision of the arbitrators shall be final, and there shall be no right to appeal such decisions in any court or judicial system. This agreement to arbitrate shall survive any termination or expiration of the agreement. Nothing in these policies and procedures shall prevent Paparazzi from applying to and obtaining from any court having jurisdiction a writ of attachment, a temporary injunction, preliminary injunction, permanent injunction, or other relief available to safeguard and protect Paparazzi's interests prior to, during, or following the filing of an arbitration or other proceeding, or pending the rendition of a decision or award in connection with any arbitration or other proceeding. Additionally, any dispute a consultant has with Paparazzi for any act or omission related to or arising from this agreement must be brought within 1 year from the date of the alleged misconduct. and by accepting this agreement, said consultant waive all claims that any other statute of limitation applies. Further, by accepting this agreement, the consultant agrees and covenants not to file suit against Paparazzi, any of its affiliates, subsidiaries, officers, directors, or employees for any claim or grievance the consultant may have arising from the status as an independent consultant of Paparazzi. Jurisdiction and venue of any matter not subject to arbitration shall reside in Washington County in the state of Utah unless the laws of the state in which the consultant resides expressly require the application of its laws, in which case that state's law shall govern all issues related to the jurisdiction and venue. The Federal Arbitration Act shall govern all matters relating to arbitration. The laws of the states of Utah shall govern all matters relating to or arising from the agreement unless the laws of the state in which a consultant resides expressly require the application of its laws. So listen, that was a lot. That was 10.3, arbitration and jurisdiction. So please make sure, if you think this fits you, or there might be some potential that there's going to be some disputing and claiming and grievancing, go and read 10.3, all right? Because that's a pretty lengthy subsection. All right, 10.4, product liability claims. Paparazzi maintains insurance to protect the company against product liability claims. Paparazzi's insurance policy contains a vendor's endorsement, which extends the coverage to independent consultants, us, so long as they are marketing Paparazzi products in accordance with applicable laws. So we got to be following the Paparazzi way in order for that insurance to extend to us, and so long as we are marketing in accordance to regulations and the agreement, Paparazzi's product liability policy, and the agreement, excuse me, I skipped the period. So basically, Paparazzi does have insurance to protect them against product liability. That extends to us as long as we are doing it the Paparazzi way, all right? And everything I've been reading up to this point in these policies and procedures is the Paparazzi way. All right, let's see. Paparazzi's product liability policy does not extend coverage to claims that arise as a result of a consultant's misconduct in marketing, reselling, or representing the product or company. So if there's any type of misconduct in the way that we do things, if it's against the Paparazzi way, then that product liability policy does not extend to cover any claims for us. And guess what? That's it. Section 10's over. So Section 10 was called Dispute Resolution and Disciplinary Proceedings. And I'm going to end this video and I'm going to hop right into Section 11 because that's only a page long, and then we're done with policies and procedures. Section 11 is inactivity and cancellation. And then we're on to some juicy training. Juicy, juicy, juicy. I'll see you momentarily.